Right, to better understand this big development, I'm of course being joined in by my guest, Swapnil Kothari, senior lawyer, as well as my colleague Harish to break this down for us. Good afternoon to the both of you. Thank you very much for taking the time out and speaking with us here at Mirror. Now, Mr. Kothari, I'm going to come back to you in a couple of minutes. Let me straight go across to my colleague Harish. Harish, very important points that have been made by the Supreme Court as far as this verdict is concerned. Essentially, tell us now with this deadline that comes into context, what's a key takeaway that we should know now?
In fact, we would have heard what the Chief Justice said in the operative portion, said that after issuing a fresh deadline of tomorrow for the SBI to furnish all details with the Election Commission of India and asking Election Commission of India to further upload all these details by 5 o'clock March 15, Supreme Court has made it very clear that we are putting the SBI on notice, and in case of any willful disobedience of the Supreme Court order, action will follow. And as of now, the only relief is that the Supreme Court has not issued any contempt notice against the SBI, but has reserved very strong words and refused to extend the deadline. Remember, what is important is that SBI had sought a deadline, fresh deadline of June 30, citing several complications, complexities, and practical problems involved in publishing all the details, primarily saying that the decoding process and also matching the details of the bonds, the donor and the beneficiary parties, and had not been matched. Supreme Court said even in the February 15 order, we have not said that all these should be matched with each other, and you just have to furnish whatever details you have to the Election Commission of India, which has to upload all these details on its website. But now, going by the order, tomorrow is the deadline given by SBI to give all the details to the Election Commission, and Election Commission has to, by 5 o'clock March 15, upload all these details on its website. And coming to the hearing, there were several stinging observations by the Chief Justice asking why you have rushed to the court last minute, what have you done for the last 26 days, and even in your application seeking extension of deadline, you have not said what you have done till now, and at least as part of part compliance, what you have done. You are just coming straight to the court 2 days before the deadline and asking for an extension till June 30. This is just not done. You have to comply with the order, otherwise it will be deemed as willful disobedience of the order, and strict action will be following. In fact, the Supreme Court also took very serious note of the fact that it is an affidavit. The application has been drafted by an AGM of the SBI, and not even a senior officer. And Supreme Court has sought a compliance affidavit from none less than the CMD of the SBI in this regard, and said that any violation of this order will be taken very seriously. Back to you.
Right, Harish. I appreciate you getting us all those details and, of course, breaking that very important verdict down for us. But for the moment, we leave it at that. But Mr. Kothari, of course, continues to stay with us. Mr. Kothari, of course, my colleague Harish was taking us through the important developments. But one thing that he, of course, pointed out were those stinging remarks made by the top court, including questioning the inaction. How do you look at this right now, legally speaking, of course?
Well, I think the Supreme Court has made it very clear that for 26 days, if you do not show the progress that you have done in your application, we will not be inclined to grant you extension. It's basic legal knowledge that when you put an application for any extension, and especially in a matter with this sort of ramifications, greater ramifications affecting the society at large when it comes to electoral bonds, and you're the State Bank of India, what you are expected to do is to show to the Supreme Court that this is what we've done so far, and these are the reasons, this is where we are stuck, and that's the reason why we need end of June, end of April, end of May, or whatever. And basically, we will always, as advocates, ask for end of June, because then we know that at least we'll get till the end of April. But if you do not show any progress that you've done in the 26 days, and you just come out with an application, and that too 2 days before the deadline, then the Supreme Court, or any court for that matter, much less the Supreme Court, would be any more inclined to give you any extension, even of a single day, because you've not justified the delay. You have not justified the extension. You have not made out grounds for extension, to put it very simply. Even if you are one of the best lawyers in the country and you argue that matter out, and you say that that silos, there are separate information in silos and we need to match, etc. and all of those things, the court is not going to be very, very inclined to grant in your favor simply because it does not find any reason. It considers, first of all, if I was a lawyer for the State Bank of India, I would have advised them not to come out with an application of this nature because it's a waste of their time and it's a waste of judicial time. The Supreme Court has indulged you for 10 minutes, and that too because of the electoral bonds judgment. Otherwise, these sorts of applications with absolutely nothing in the application to show a justification for an extension would be dismissed in 2 minutes flat. So the thing is that the lesson to be learned from this is that, okay, you have deadline till tomorrow 5 p.m. Comply with it. Otherwise, you'll invite a contempt proceeding. And by the 15th of March, the Election Commission of India will have to upload the details on the website. So the court wants to put an end to this issue. The court has given an electoral bonds judgment. It has jumped them on the basis of opacity. It has set aside the mayoral election process results of Chandigarh. And finally, it has come out with a judgment that the legislators are not immune from any prosecution under Article 105 or under Article 194 if they take bribes for giving votes or making a speech. So with these three judgments, the Supreme Court has laid out the procedure for democratic polity. It has said that the democratic principles in this country are paramount. The right of the voter is supreme, and the right of the voter becomes supreme only when he is informed. And he can only be best informed if there is free speech, if there is freedom of press, and if there is transparency. No transparency, electoral bonds are out. Mayoral election process set aside, results set aside, because the results were vitiated with malice and with some sort of favoritism there. And prosecution, of course, for bribery. If you take votes and make a speech on the basis of bribery, then you are no longer a legislator. You basically are just a corrupt public servant. So the Supreme Court has said with these three judgments of its in the past 1.5 months or 2 months, that we are very serious about the democratic principles of this country. And more so if you are the State Bank of India, you need to be more prudent. You should have done this job yesterday. In fact, I would have expected, I as a Supreme Court judge, this is what would have been running in their minds, that we will not wait till the March 12th. We will wait till, in fact, it should have been ready in their in the Supreme Court registry by March 6th or March 7th, a week before that. All the information should have been there because every information is available to you. You just have to put that on an affidavit and would have been over and done and dusted with. So the Supreme Court, by passing this judgment, has clearly said that we are not inclined to get into this further. We have more pressing matters, more important matters, and let's put an end to this once and for all.
Mr. Kothari, as you make those opening remarks and, of course, essentially are talking about how the Supreme Court looked at this, one of the arguments that was made by the petitioner, of course, in this case, Harish Salve, representing the SBI, was the complexities of this case. But, of course, the CJI spoke about the fact that the electoral bonds do have a unique identification record and shouldn't have been that much of a problem to collate this data.
Absolutely. And that's exactly what I'm saying. As lawyers, we will always, if we are representing our clients, even if it's the whatever, whether it's SBI or any bank or any individual for that matter, we will try to make out the best case possible. We will use words like complexities, separate information in silos. These are all, should I say, not very clear arguments. But then we as lawyers tend to make them out day in, day out. We do that. That's our job. And we wait for the judge to see whether he's inclined to even give us till the end of the March. But looking at the situation, I think the Chief Justice of India was not really inclined, even for possibly even an hour more than 12th of March 5 deadline, whatever that 5 p.m. deadline. And that's exactly what he did. So complications, complex proceedings, complex matters, these are all very, very beautiful terms. But when it comes down to elucidating or expounding them before the court of law, you need to be a little bit more specific as to what is so complex and where is it that you have been stuck. And absent these two information, absent these two things before the court, you will not succeed.
Mr. Kothari, and before I let you go, just a quick question with the fact that the Supreme Court, of course, has asked details about donors and which party got donations. But is this a catch-22 situation to read into, that not which donor is donating to which party?
Well, we need to know that. The voter needs to know which donor is donating to which party. And if the electoral bond is something... See, I'll tell you one thing. There are two sides to this particular judgment. Like one of those is that it's opaque. we need to, we need to junk them. The other thing is that any which ways, if it's the electoral bonds, there are bonds, these are there out in the open. So there will be information there somehow really once somebody wants to dig into and find out as to who donated how much. But the point is that on the face of it, the Supreme Court found them to be opaque, not transparent, and the voters do not really have that kind of time or may not have access to that information. So let's make it very clear, right? Let's make it easier for the voter when the Election Commission posts it, uploads it on the website. So the thing is that, yes, I need to know which donor is donating how much to whom, because then we know what are the mechanics in this country. And this is not the only first time, this is not the only country. It happens in the United States, it happens in the United Kingdom, it happens in all countries. But then there is a more voter is more informed there are more checks and balances. So the reason is that we are only about 75-year-old democracy. We need to, and we have over 1 billion population. And some of the people are still very naive. And let's make it very simple for them. And what is the harm? If I've donated something to a political party, I should be open and confident about it that I have done so because I believe in the manifesto of the party. So why do you want to hide it? The reason why you're possibly hiding it is because you do not want to invite the wrath of the other party that you have not donated to or you've donated less to. So the voter is not concerned with that. The voter is concerned with the fact that you've donated X amount to X party. And what is the reason behind it? Let me decipher that and let me go and cast in my vote. That's as simple as that. Right to vote is a very, very important right. It's not a fundamental right, but it's an important right. So I need to know that. And if it flows from the right to freedom of speech, where is the right to information? So right to information is a fundamental right. So that information, if it's hidden from me, that means my fundamental rights are being violated by an electoral bond scheme, which needs to pass the test of Article 14, 19, and 21, which any needs to pass. And they need to pass, this kind of a scheme needs to pass the 3 tests as doctrine as what we call.
Mr. Kothari, although you're getting us all those important
things.
perspectives as to how you see this, I'm afraid I'd have to interject you there. But for the moment, I appreciate you once again taking the time out and joining us here this afternoon and on Mirona. Thank you so much.